Hello and welcome back. This is Roger Royce with the 10,000 Startups podcast, where each week we bring you original content from legal experts and specialists on topics of interest to startup companies. I'm a partner with Haynes Boone. I do emerging growth and venture capital in Palo Alto. But today we're going to talk a little bit more about intellectual property issues, especially around OpenAI and particularly around Scarlett Johansson's battle with OpenAI. So I'd like to welcome Allison. She's counsel in the intellectual property practice group in our New York office of Haynes and Boone, where she helps clients obtain, enforce, and leverage valuable intellectual property assets. So thanks for being here, Allison. This is a really sort of topical and interesting and novel issue, isn't it?
It is novel considering the technology. And I think what is so fascinating about the kind of intersection between technology and the law is that I think technology a lot of times shows us where the law has holes. As this case that we're going to talk about and generative AI and publicity rights, it really just draws out the fact that technology is amazing and fascinating and really can kind of show us where we need to adjust so that we can keep things moving.
Okay, well, maybe do you want to tell us a little bit about what the dispute is as reported in the media between Scarlett Johansson and OpenAI?
Absolutely. So I really actually think that this is such a cool instance of life imitating art. So just to start off with a little bit of backstory for those of you that aren't aware, Scarlett Johansson, who is a really well-known actress, is really known for playing, in addition to Black Widow on all of the Avengers movies, is known for playing an artificial intelligence voice assistant in the 2013 Spike Jonze movie called Her, Her. So it starred Scarlett Johansson and Joaquin Phoenix. And it kind of talked about this gentleman that fell in love with his AI voice assistant. And so here, 10 plus years later, we have OpenAI, who they're an artificial intelligence research organization. They approached Scarlett about 9 months ago, asking her to be the voice of OpenAI's new voice assistant called Sky. Now, query whether Scarlett and Sky might be a little closely connected here. I'll leave that for you guys to discuss. So OpenAI CEO Sam Altman has already previously said that the movie Her is one of his favorite films. And so it seemed really fitting that he was hoping to have Scarlett be the voice of Sky. So even, just right up to the leading up to the release of Sky, Altman even tweeted just the single word her in relation to the announcement of the film. Well, so 9 months ago, Altman had reached out to Scarlett. She had declined. About 2 days before the release of Sky, so a couple of weeks ago, 2 days before the release of Sky, Altman reached out to Scarlett again, asking her to reconsider. But before she could answer, Sky was released. And to Scarlett's surprise, Sky's voice sounded an awful lot like her own. So Scarlett says she was shocked, she was angered, she was in disbelief that Altman would use a voice that was so eerily similar to her own. So OpenAI, for its part, has denied that there was any connection between Johansson's and Sky's voice, just saying it was just coincidental. Certainly after a few demand letters from Johansson's legal team, OpenAI paused the use of Sky and did apologize. They confirmed, or at least are stating, that the voice that was used for the launch of Sky belongs to a different professional actress, but they are not confirming who that actress really is. And I think it's really interesting if you've had an opportunity to go listen to the similarities of Scarlett Johansson's voice compared to Sky when it was released. I will say, to me, it does sound an awful lot like her, Scarlett Johansson. So what's interesting also is that I think OpenAI was really hoping that they could use a voice. This is something that they kind of had approached Scarlett with, it. They were hoping they could use a voice that would be comforting and maybe, help to make people who are a little bit leery of AI feel a little bit more comfortable working around AI. But I think that has totally backfired here based on Scarlett Johansson's kind of allegations of this breach of trust. And so I do think that there's some irony there, that I think they were hoping that they were going to create this scenario where people would feel more comfortable with a familiar sounding voice. And it just, now none of us are comfortable. None of us are safe from AI.
Yeah, you know, what I love about this is, first of all, I think Lost in Translation is like one of my favorite movies. And Scarlett Johansson, you know, she was the world's highest paid actress in 2008 and 2019. So certainly one of my favorite movies, and OpenAI is one of my favorite companies, but only because they give me so much content for my podcast, because they're just generating legal issues every time I open up a newspaper, novel issues.
Yeah.
So let me just kind of cut right to the chase. Does she have a right to her voice?
Absolutely. Although I guess I should be a lawyer and say it depends. It depends on what state you're in. Because really these issues of image, of voice, of personality, all fall under the rubric of personality rights. So generally, under the law of the right of publicity, a person has the right to their name, image, likeness, and their voice, and they need to grant permission, and their rights in their right of publicity can be violated when their name, image, likeness, voice are used without permission to promote a business or to promote a product. What is interesting is that the right of publicity is right now generally just a state law. So we talk about copyrights and trademarks and patents. Those fall under the rubric of federal law. But the right of publicity at this point is really just limited to state law. And certain states, as you would suspect, have stronger right of publicity laws than other states. I think California, New York have very robust right of publicity case law. Other states may not have that at all.
Yeah, you would expect that in California, that this issue has come up many times, and we've got a very well developed law on this. So it sounds like on that particular piece, the right of publicity, if I'm getting this right, it sounds like a very intensely factual issue as to whether this is in fact her voice or not, right?
It is factual, and then there's also, kind of we want to talk about like how a jury might interpret it. There is some interpretation there. I want to kind of like shift a little bit more to talking about that. There's a really famous voice case that came out of California that was Bette Midler versus Ford Motor Company. If any of you are familiar with it, that case from California is actually really apropos to what's happening here. So in that case, Ford Motor Company was creating commercial campaigns for the Mercury Sable, and they wanted to inspire feelings of nostalgia by using famous songs from the 70s that were sung by the original artists. And so they were reaching out to artists, asking them to sing these songs in their commercials. They reached out to Bette Midler. Bette Midler said, "No thanks, not something I'm up for." And so Ford turned around and hired a voice impersonator to sing one of Midler's songs. Midler sued in district court in California. The district court held for Ford, saying, sorry, there's just no legal principle here that would prevent the use of a voice in this way. So Midler appealed to the Ninth Circuit. The Ninth Circuit in California, well, not just in California, but the Ninth Circuit in general, held that Midler's distinctive voice was part of her identity and that it could not be imitated without her approval. And so the Midler case really confirms that it doesn't have to be an exact replica in order to be actionable. And so it kind of takes it, going back to your question, is it very highly fact specific? I think there is room for interpretation that in this case, in the Midler case, it didn't have to be an exact replica in order for there to be a violation of Midler's rights of publicity. And so I think, I feel like it's just, so closely connected to the Scarlett Johansson case here, where you have an actress whose voice sounds so similar being used for Sky. And, it'll be interesting. Time will really tell. I don't know that if, at this point, we don't know who this actress was. and what the intent was behind hiring this actress when Scarlett declined. But
That's a good point. That's right. There is a real person behind the voice. It's not like AI.
well, we hope maybe it's an AI voice.
Well, that's what we're wondering. It's like, I heard about a robot that gave a commencement speech last week, so I suppose it's
Right,
possible.
right.
So that's the state side. On the federal side, when we think about AI and IP issues, we automatically, our minds go to copyright because we're worried about AI going and copying maybe one of my awesome blog posts and reposting it or
Right.
something like that. And I've seen some chatter in the media about this where the media immediately goes to, well, must be copyright, whatever that means. What is the federal law that might protect Scarlett in this case?
Right. So right now, there's not a federal law to the right of publicity. And you have heard, just as I have, there's been some chatter about, oh, this is a copyright issue, because a lot of AI issues do involve copyright issues. Copyright is the protection of anything that is set down in a medium that is not an idea or an expression, but something that's actually, physically or visibly viewable. And so copyright could kind of come into play in an AI issue. Here, though, however, where we're talking about voice and likeness and distinguishing features for an actress, it really is not a copyright issue as much as it is a right of publicity issue. And because there's no federal right of publicity law, and because it's a state issue and sometimes relegated to the entertainment space, it's not something that we might think of right away, but there certainly are rights there. And it's unfortunate, that there's not really a federal law at this point. Like we think about copyright and we think about a DMCA takedown and a trademark infringement complaint, how it's relatively easy to get trademark infringements, copyright infringements removed from online. And it is not relatively easy at this point to get a right of publicity issue addressed unless you can attach it to something else. If you could say, hey, this is actually an image of Scarlett Johansson that's connected to the voice, so we've got a voice issue, but we've also got a copyright issue because it's her face, then you can rely on copyright law to get it taken down. But in this instance where we're just talking about voice. Oh, sorry.
Yeah. Can we pause on that for just a second? I'll make sure everybody understands what a takedown notice is under the DMCA. Can you explain? Again, we understand it only applies to copyright, so it won't apply here, but what is it?
Right. So a DMCA takedown request is a request that you would make to a platform, to an internet service provider, notifying them that your copyright has been violated in some way, whether it's someone using your music without authorization, somebody's using images from your website, somebody's using your copyrights without authorization. You can submit a DMCA takedown request. And I'll back up here. The DMCA stands for Digital Millennium Copyright Act, which was put into place to help address the issue of copyright infringement by internet service providers who were vicariously infringing simply because they were offering a platform. And so what the DMCA really does is creates a safe harbor for your internet platforms to be able to say, hey, I've received a DMCA notice. I'm going to, as the platform provider, remove this, and I have removed it. And so I'm no longer secondarily liable for copyright infringement.
Gotcha. And we don't have a parallel process for this kind of case, do we?
Not right now, but there's always room.
Okay, well, I'm going to get to that in a second. But before we do, pending legislation, what does this mean for those of us who are not famous Hollywood movie stars? Should we be worried about what OpenAI has done here? If they have done anything, I'm not saying they have. Or is this just kind of a one-time thing that only affects one person?
So I think that the answer here is yes. Definitely, I think we appreciate why actors and the entertainment industry is highly concerned about this, and we'll talk about that in a second, because you've got generative AI that's able, potentially able to replace actors, and so that was actually a big part of what the SAG-AFTRA strikes were this past summer. We're dealing with these these issues of this technology being able to come in and replace actors who, may be seen, they're kind of seen as we have to pay out for this. And now if we can just use technology to create our actor, then we don't have to pay this big salary, and maybe the studios get to, keep a little money, or the money goes elsewhere. I think if we just sidetrack for a second and talk about the contractual issues involving an actor's name, image, likeness, their right of publicity. Generally, in every entertainment contract that you're going to see, the studio, whomever the producers are, they're going to ask for a license to the right of publicity of that actor, because they need to be able to promote the film, or we're just going to talk film or television series. They need to be able to have commercials. They need to be able to have the actor's face or voice in the commercial. Maybe they're going to do merch. Maybe there's going to be popcorn buckets. I have the popcorn bucket at home with Jason Momoa as Aquaman on it. There was a license to Jason Momoa's right of publicity in order to be able to put his visage onto this popcorn bucket. And so that clause historically has basically just always said, we have the right to use your name, image, likeness in all medium now known or hereafter devised. And that to me is like the scariest language of all. And as an attorney who has put this clause in lots of contracts, it's really important, because you want to be able to have the right to use the publicity rights or that you're being granted in ways that you might not even be imagining right now. But it has created an issue where you've got all these studios that have contracts, dating back for years and years and years, that say, hey, I have the right to use your publicity in order to promote my film. Or maybe it's not even, sometimes it might not even be limited to the film. It could be limited. It may not be limited at all. And so you have entities and studios and production companies saying, well, hey, we actually have this license that gives us to us in perpetuity. And for any medium now known or hereafter devised, that means we've got a right to your right of publicity. And so that was a big piece of the SAG-AFTRA strikes, was, talking about how do we compensate actors? How are we making sure that there's ethical use of their rights of publicity and their imagery? When you certainly have the contract that you could rely on, but is it ethical to do that?
Right.
And so, but taking it back to just, everyday people that are not necessarily actors, maybe we don't necessarily have value, like commercial value, in our voices or in our appearance or in our characteristics. However, where I do think we should be concerned is in the realm of deep fakes. And we think about, I'm going to take it to a dark place for a second, but you think about maybe revenge porn or other content that could be created using generative AI in order to attack someone. Maybe it's a spurned ex, or it's somebody that just has it out for another person. They
or
could
like what they
potentially
did
use
to
this.
Taylor Swift, right?
Exactly. And so while we do see this happening with celebrities, because there's a huge maybe commercial value there, where I think we should be concerned is in the ability, that generative AI has to potentially impact our own reputations.
Okay, well, I think the
So
answer.
sorry, that was
yes.
like Halloween scary there.
Yeah, but the answer is yes. This is a real issue. This is something we should all be concerned about. So let me kind of circle back to what's my representative going to do about this? What's Congress going to do about it?
Right.
Is there anything pending?
So yes, there is a bipartisan bill right now in the US Senate. It is called the No Fakes Act, which I love their use of acronyms. I think they have like the highest paid acronym creators on the planet working in Congress. So
It's
no
probably
fakes.
AI doing that, but
Oh my gosh. See, now we put someone else out of work. No Fakes stands for Nurture Originals, Foster Art, and Keep Entertainment Safe. That was pretty clever. Anyways, it is a bipartisan bill in the US Senate that is seeking to protect performers from unauthorized digital replicas of their personality rights. And the No Fakes Act is seeking to hold companies and platforms liable for producing fakes. And one thing like that the No Fakes Act talks about is, you know, that this is happening more regularly. You brought up the Taylor Swift issue. I know a few months ago there was something about Tom Hanks and how there was an ad using his digital replica to promote a dental plan. And he came out and he's like, listen, I don't use this dental plan and I never appeared in this commercial. This was not me. There was a song called Heart on My Sleeve that was created using AI generated replicas of Drake and The Weeknd. And this song like hit big, quickly accumulated hundreds of thousands of listens. Drake and The Weeknd never made this song. So, and then, you know, on top of that, regardless of the ethics of it, you think about, well, okay, well, who is going to own the composition rights and the sound recording rights to that music, and who's getting paid for what? And I think it's an interesting time. This is just an interesting kind of tag on to talk about copyrights and AI, and that the U.S. Copyright Office has come out and said, we refuse to register anything that is generated by generative AI, by artificial intelligence. So right now, if you were to use AI to create some work of art, the Copyright Office would refuse to register it. So there's a lot happening in other spaces of IP, recognizing or failing to or refusing to recognize the rights in works that are created by AI.
Right. So at a high level, the No Fakes Act, it would just prohibit the unauthorized use of digital replicas without consent, even if there's no contract, correct?
That's my understanding. And then it would create a liability for the production of those unauthorized digital replicas.
Oh, so
and of course, as we know, bills get morphed and change into different things, but yeah.
So there'd be what we call a private right of action under this law.
Potentially, yeah.
Yeah. And I understand some of the states have also gotten in on the act. Here's my favorite one in Tennessee, the Elvis Act, ensuring likeness, voice, and image securities. You know, they definitely, you're right. They ought to get awards for coming up with those.
They really should. That's what Elvis is standing for. You know, I wonder if there's a trademark issue there.
Good one. Okay, I guess the final question is, I mean, is the law even able to keep up with the technology in this space these days, especially, you know, given, I mean, this is a bipartisan bill you just mentioned, but given what I've seen on YouTube lately about what's going on in Congress, I wonder how they get anything passed. Even on a good day, can they keep up with how fast this technology is moving?
You know, with good people at the helm, I think it's possible. I think, you know, AI is underscoring the importance of protecting rights. And I do think that, you know, I said it at the top of the podcast, that technology a lot of times shows us holes in the law that need to be plugged. Technology can really serve as a stress test for where we have weaknesses in our laws and where we need to maybe act to protect certain rights in order to preserve things. I think that that's really the issue here, is that we do need to have some stopgaps in place in order to preserve and promote the arts. That was the reason that the Copyright Act was created. That was the reason that you know, trademarks and patents have become protected pieces of IP. It is in order to promote innovation and to promote creation. And so here, I think with AI really becoming so much more mainstream, and we're seeing the capabilities of the technology, I do think that we are seeing holes, and hopefully we're able to plug them appropriately. And I do think it takes a lot of voices in the room to say, hey, here's an issue. How do we solve this? There are certainly First Amendment rights that cannot be ignored, and that shouldn't be ignored. You know, that's another counterbalance here, is the First Amendment factors that come into play here. They certainly should not be ignored, but there needs to be a balance. Gotcha. So yeah, technology develops at light speed, and it is just getting faster and faster. And so yes, it's a challenge to keep up with it, but I do think it's possible.
All right. Well, on that note, I want to thank you, Annie, for being here to talk to us about Scarlett Johansson versus OpenAI. And by the way,
Absolutely.
I'm not suggesting there's any pending litigation. I just use that since that's what's been going on in the media and the issues that their negotiations has raised. This is Roger Royce. This has been the 10,000 Startups Podcast. Thanks for listening. We'll see you next week.